ladies and gentlemen. The very word secrecy is repugnant in a free and open society, and we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweighed the dangers which are cited to justify it. Even today, there is little value in opposing the threat of a closed society by imitating its arbitrary restrictions. Even today, there is little value in ensuring the survival of our nation if our traditions do not survive with it. And there is very grave danger that an announced need for increased security will be seized upon by those anxious to expand its meaning to the very limits of official censorship and concealment.
These words are a ringing condemnation of the process under which the intellectual property laws have been drafted, developed, and implemented. Strong language perhaps, but justified by the facts. Facts which show that the multinational companies have driven adoption of stronger intellectual property laws through a process that is a secret and excludes any interests that oppose them, such as organizations like ours. In this submission we will not only examine the public statements made about ACTA, but also the historical background of ACTA. We will show that there has been a hidden agenda to pass intellectual property legislation, and that the only balance introduced was achieved through a public campaign to protect our rights. In every other way, the intellectual property agenda has been set not by our sovereign government, but by multinational companies. The Digital Millennium Copyright Act is a United States copyright law that implements two 1996 treaties of the World Intellectual Property Organization. It criminalizes production and dissemination of technology, devices, or services intended to circumvent measures that control access to copyrighted works. It also criminalizes the act of circumventing an access control, whether or not there is an actual infringement of copyright itself. In addition, the DMCA heightens the penalties for copyright infringement on the Internet. It is interesting to compare aspects of the DMCA with the digital provisions of ACTA and Copyright Amendment Act 2008. It is clear that the provisions of ACTA are directly related to the DMCA. All of the above provisions, including prohibitions on DRM circumvention devices, increased provisions for copyright infringement, and rules around limiting the liability of ISPs, is addressed in ACTA. Clearly, ACTA is an attempt by the United States to export its DMCA intellectual property regime to other jurisdictions. So what can we expect from DMCA-style laws if implemented in New Zealand? A good example is the case of Venom Fang X, a fundamentalist Christian who filed hundreds of DMCA notices against content that opposed his own views.
Venom Fang X, a YouTube user who until recently had some 27,000 subscribers, has a history of abusing the Digital Millennium Copyright Act. About 15 months ago, in October of 2008, he was constrained to read this apology after filing about 150 baseless DMCAs.
This is an apology from myself to Thunderfoot and other YouTube users. I confirm that the contents of this apology are true and accurate. My username on YouTube is VenomFangX. As many of you may know, there has been a dispute between Thunderfoot and myself over the past few weeks. We have resolved that dispute, and as part of the resolution, I am here to express my regret for the misuse of the Digital Millennium Copyright Act to serve takedown notices in relation to a number of Thunderfoot's videos on YouTube.
On the 5th of January 2010, he filed another 30 baseless DMCAs, including ones against DPR Jones. DPR Jones subsequently filed counter-notices and told VenomFangX that he would pursue the matter further unless he left YouTube for a year. VenomFangX then maliciously put up a doctored video claiming that a 20-something aged woman showing her breasts for a charity blog event was in fact DPR Jones soliciting a 17-year-old girl to show her breasts.
So what does the evidence say about the DMCA abuse? In 2005, Jennifer Urban of the Intellectual Property Clinic of the University of Southern California published a study of takedown notices under Section 512 of the Digital Millennium Copyright Act. She found that 30% of notices demanded takedown for claims that presented an obvious question for a court, such as fair use arguments, complaints about copyright, uncopyrightable material and the like. Notices to traditional ISPs included a substantial number of demands to remove files from peer-to-peer networks, which are not actually covered under the takedown statute, and which an OSP can only honour by terminating the target's internet account entirely. 1 out of 11 included significant statutory flaws that render the notice unusable, for example, failing to adequately identify infringing material. In the process of considering the new copyright bill, it went to Select Committee, where people had the opportunity to present their submissions. Section 92A allowed for copyright holders to file notices, and for individual internet connections to be terminated based on those notices. This approach was widely condemned, with Internet New Zealand saying, "A deeply flawed law that undermines fundamental rights and simply will not work." That is what the telecommunications industry, internet service providers, user groups, internet advocates and IT professionals think about parts of the recently passed Copyright New Technologies Amendment Act. As a consequence, this section was removed by the Select Committee, only to be reinstated by Judith Tizard shortly before the legislation was passed. A subsequent meeting by Judith Tizard was reported by Colin Jackson. When it opened, Judith Tizard spent 30 minutes telling us why the change had to be made. She began by strongly expressing her anger that we had complained to her at this stage of the proceedings. None of us, she said, had been to see her before on this topic. When we protested that we had worked with the Select Committee, which had removed the provision and balanced it with one which made licence holders liable for false accusations, she said that it was completely inappropriate for the Select Committee because Cabinet had already decided it was going ahead. We should not have been surprised, we were told, that this provision was reinserted by the government at the last minute before the bill was passed. After the bill passed into law with the section in question intact, there was an open question about why it was necessary for the government to override a decision made in Select Committee that was made in consultation with a huge number of experts in the industry. How was it possible that a Minister of the Crown was able to suggest that the Select Committee was not the appropriate place to provide input to government, when it is the express purpose of the Select Committee process to do this? More importantly, what invisible agenda was driving the adoption of legislation in direct opposition to the vast majority of New Zealand citizens? As a consequence of the undemocratic treatment in the aftermath of the Select Committee, a campaign was developed and headed up by the Creative Freedom Foundation to pressure the government into delaying and revising the implementation of Section 92A. This included hundreds of websites blacking out their websites in support of the cause. The new national government considered the position and decided to initially postpone the section, and then later decided to redraft the legislation. When we are critical of the transparency of the ACTA process, it is not because we have an academic interest in the subject. It is clear that the Copyright Amendment Act 2008 was at the very least engineered to enable the same kinds of provision as the DMCA has around ISP liability, disconnection of individuals, and provisions around technological protection measures. When a provision required by that agenda was reversed in Select Committee, the government acted to reinstate it. It is very clear that there is a secret agenda at work to introduce every provision of the DMCA in New Zealand. Furthermore, this is an agenda set by the content companies that come at the expense of our freedoms and privacy. This is not speculation. This is a documented fact, as in evidence in the United States, where the DMCA has been in effect for more than 10 years. It is in this context that we are calling for transparency. We do not wish to see hidden agendas influence agreements negotiated in secret decide what the laws of New Zealand will be. We fear the new concessions we have achieved will be reversed in order just to get to the negotiation table with the United States for a free trade agreement. The text of proposed agreements has not been officially released. Briefings by the Ministry of Foreign Affairs and Trade have tried to explain that ACTA is an agreement only about enforcement and not affect our human rights. In the sense that this statement is true, it is trivial. In the sense that it is important, it is false. It is true that ACTA itself will not directly affect our human rights, privacy or freedoms. This is because it is a trade agreement without force of law. In the larger view, one that incorporates both the legislation that has already been passed and any future legislation in support of ACTA, our rights and freedoms and privacy will definitely be affected. So what are the recommendations of the NZOSS? At the very least, we do not wish to see the following introduced as a consequence of ACTA. 1. A regime where citizens will be disconnected from the internet based on notices from rights holders, but rather maintain a position where proper judicial oversight and process will be maintained. 2. Extension of technological protection measures beyond the right of duplication to include, for example, playback and access rights. Furthermore, we'd like to see the proper application of transparency and accountability in decision making to ensure decisions are made in the open and in the interests of New Zealand.